Good afternoon, class. Today's topic is Chapter 2, Obligations of the Partners. So we will begin with Section 1 of that chapter, Obligations of the Partners among themselves. But throughout the chapter, you will learn later on that Section 1 does not exclusively talk about the obligations of the partners among themselves, but will also talk about the obligation of the partnership with the partners. So remember, class, when we enter into a contract of partnership, there are 4 relationships that are created. Number 1, the relationship among partners themselves. Also, the relations of the partners with the partnership. There is also a relation of the partnership with third persons and a relation of the partners with the third persons. So remember, these 4 are the relationships created in when you enter into a contract of partnership. So also remember that before we proceed with the duties, you have first to know kailan ba nagsisimula ang isang partnership. So a partnership begins, number 1, according to 1784 as a general rule, from the moment of the celebration of the contract. So being a consensual contract, remember, from the time that the parties give their consent, there is already a partnership formed. Pumayag si A, pumayag si B, there's already a partnership, even if the details are not yet specified. Remember, the only exception to this is in case of a limited partnership, which requires registration with the SEC. Pagka na-register na sa SEC and the SEC issues a certificate to this effect, that is the only time that the limited partnership will commence. Also, in cases of partnerships wherein immovables are contributed, so magsisimula pa lang ang partnership if there is already a written instrument, public instrument, that is executed by the partners, and also there is an inventory attached to the public instrument. Remember, in the absence of any of these instruments, yung inventory at saka yung notarized articles of partnership or contract partnership, the partnership here where immovables are contributed is void. So yun ang general rule. Exception, so remember, the exception is when there is a contrary stipulation, meaning that the partnership will start after a specified period. So the partnership here is to be formed at some future time. So pagka dumating yung future time, here we are talking about a period. So pagka dumating yung period stipulated, that is the only time that a partnership will begin. Also, a partnership can start upon the happening of a future and uncertain event. So remember, pagka nangyari na yung condition, future and uncertain event, that is the only time the partnership will begin. So yun ang mga exceptions. Also, in 1785, we will talk about gaano katagal ang isang partnership. So the duration of a partnership actually depends on what kind of partnership it is. If it is a partnership at will, or it is a partnership with a fixed term or a specified undertaking. So remember, if it is a partnership at will, the duration is depending upon the agreement of the parties. Pagka ayaw na nila, then then the partnership will be dissolved in accordance with the will of the partners. So walang time limit is fixed. What else? Also, if the partnership is for a fixed term, ang duration niya is hanggang doon sa fixed term. And also, if a partnership is for a specific undertaking, ang duration niya is hanggang doon sa accomplishment ng specific undertaking. So remember, as soon as the undertaking is accomplished, the partnership will end. So let's begin with the obligations of the partners. So Article 1786 is an enumeration of 5 of the obligations. But later on, makikita nyo, mas marami pang mga obligations. Anyway, 1786 talks about 5 obligations: the duty to contribute. So remember, usually the contribution is made ordinarily at that moment of the celebration of the contract, but it can be made later on. So if a different period is stipulated, yun ang susundin natin. However, class, dapat meron talagang contribution. Hindi pwedeng wala. So there's an undertaking by each partner that they will give a contribution at some time. So anyway, if there is failure to contribute, the partner will be automatically liable as a debtor. Hindi na kailangan mag-demand ng partnership na magbigay siya ng contribution. Automatic debtor na siya. Automatic in default na siya. So remember again in your RFBT1 in obligations, anong sabi? Kailan nagiging default ang isang debtor? The debtor will be in default or legal delay when there is already a demand. So dito sa duty na to, 1786, hindi siya umaayon sa general rule. Kasi here, even if there is no demand, remember, as long as the time has come to give the contribution, the debtor/partner will be in a default. What else? Duty to warrant against eviction. Dinefine ko na yan. So, remember here, class, that if a partner donates to the partnership a specific or determinate object, the partner also has an obligation to the partner na i-maintain siya sa possession ng object. So, kailangan yung partner na yan, yung partnership will remain in the possession and ownership of the object. Ngayon, pagka ang partnership na ito ay naalis sa possession and ownership of the object contributed by a partner, it is as if itong partner na to did not contribute anything. So, it is a violation of the duty to warrant against eviction. Wala na siya kasing contribution. What else? Also, remember, there is a duty to deliver fruits. So, from the time that they should have been contributed to the time of actual delivery. Again, remember, there is no need for demand for the partner to deliver the fruits. What else? Duty to preserve property. Pending delivery to the partnership, kailangan mag-exercise ng due diligence in preserving the property. Yung partner who intends to contribute this property. What else? Letter E, duty to indemnify for damages. So, in case the contribution is retained without justifiable reason or the contribution is delayed, magbabayad ng damages ang isang partner. What else? These are the rules regarding contribution. So, remember the extent of contribution. Ano ba? General rule, commutative. So, equal shares in the contribution unless otherwise stipulated. So, remember, equality is the general rule. Commutativity is the general rule. However, there can be an exception if there is a stipulation to that effect. In the absence of any proof, the shares are presumed to be equal. What else? Also, appraisal of goods. Yung mga i-contribute nyo na goods sa partnership, kailangan malaman ang value niyan so that you know how much a partner is contributing to the partnership. So, an appraisal of the goods is therefore necessary. So, yun na nga, para to determine how much is contributed by the partner. Kasi yung contribution nila will also determine, in some cases, how they will share profits and losses. Absent any agreement as to the sharing of profits and losses, ang magiging basis is yung contribution. So, kung wala tayong appraisal or di natin alam kung magkano ang contribution, ano ang basis ng profits and losses? What else? Also, remember that appraisal of goods is made as prescribed in the contract of partnership. So, depende kung anong nakalagay sa contract of partnership, and also in default of the first by expert and at current prices. So, dun malalaman kung ano ang value ng iyong goods to be contributed. What else? 1788, duty to indemnify for interest and damages. So, remember here, class, again, if there is failure to contribute, and also, yung pangalawang case, when a partner takes money from the partnership funds. So, kumuha siya ng pera from the partnership, and also there is a failure to contribute, kailangan niya magbayad ng interest, kailangan magbayad ng partner ng damages. So, remember, class, yung reckoning point or the time that the interest and damages will be computed, it will begin from the time he should have complied with his obligation in the first case, and also number 2, from the time he converted the amount for his own use. So remember, class, magbabayad siya ng interest and damages pagka nahuli yung kanyang contribution from the time na dapat i-deliver niya yung contribution, or number 2 naman, he will be liable for interest and damages from the time he takes the money and converts it to his personal use. So, dun magsisimula ang pagbibilang ng interest and damages. What else? Also, obligations with respect to the contribution of money, kanina converted to personal use, and also with respect to delayed contribution of money. So, this has something to do with the earlier discussion. So, number 1, the partner should contribute on the due date. What else? Number 2, he will reimburse. Sana po alam niyo yung ibig sabihin ng reimburse, because seriously, in my 12 years of teaching, may mga estudyante hindi nila alam kung anong ibig sabihin ng reimburse. Remember, class, to reimburse any amount he may have taken from the partnership funds and converted to his own use. What else? Also, to pay interest. Remember here that the interest will be paid because he failed to contribute on time, or he takes any amount from the common fund. What else? Also, to indemnify the partnership for damages caused by, again, a delay in the contribution and the conversion of partnership funds to his own benefit. So, yun ang kailangan nating tandaan. What else? Additional capital may be contributed by, remember, capitalist partners will contribute additional capital. Kung industrial ka, they will not ask you to contribute capital. Siyempre, ang kino-contribute mo nga lang is industry. And obviously, they cannot ask you to contribute additional industry. Kasi nga, lahat ng industry mo as an industrial partner, binibigay mo na sa isang partnership. So anyway, in case of imminent loss, malapit nang malugi ang isang business, and there is no agreement by the partners that they will not give additional contribution. Kung walang ganong agreement, capitalist partner is obliged to give additional contributions if it will save the business. So, if he does not want to give additional contributions, he will be forced to sell his interest to the other partners who are interested in actually saving the partnership. So, yun ang kailangan nating tandaan. This will apply to capitalist partners. They will contribute additional capital. Anyway, we will discuss that more later on. Duty to bear the risk of loss. So, remember, class, pagka before delivery, it is obvious, very obvious, that it is the partner who will bear the risk of loss. So, bago niya i-deliver itong object that he will contribute and it is lost, remember, the risk of loss is to be shouldered by the partner. Because if the object is lost, it is as if, again, he has no contribution. So, hindi na kasalanan ng partnership yan kung walang contribution ang partner. Now, what if the object has already been contributed or delivered to the partnership? So, these are the rules when the object has already been contributed or delivered, still covered by the same article 1795. So, in number 1, remember, the object is specific and determinate, and remember also not fungible, and only the use of rock is contributed by the partner. So, ang kinontribute lang is yung gamit, but the ownership remains with the partner. Obviously, the partner will bear the risk of loss. Here, class, it follows the general rule of res perit domino. Owner bears the risk of loss. That's why it is the partner who will bear the risk of loss. Here also, that if the object is destroyed, it is as if the partner did not contribute anything. What else? Number 2, same specific and determinate object, but the ownership is transferred to the partnership. So please take note of the phrase, ownership is transferred to the partnership. So if the partnership is the owner already, obviously, it is the partnership who will bear the risk of loss. Again, res perit domino. What else? Also, number 3, if what is contributed is a fungible thing, or yung things which cannot be kept without deteriorating. Remember, class, the risk of loss is borne by the partnership, because here there is an obvious transfer of ownership. Kasi nga, pagka ginamit mo ang mga fungible things na to, they have to be consumed or impaired. Let us say, ano bang example ng fungible things? Rice or wine, etc. So, if you contribute rice to the partnership, obviously, hindi siya pwedeng gamitin nang hindi siya nauubos. So, pagka ginamit mo siya, mauubos siya, ito ay, pagka nawala itong object na to, partnership will bear the risk of loss. Kasi nga, nung ginamit mo siya, nawala siya. And remember, class, it is the partnership who will bear that loss. What else? Things contributed to be sold. Obviously, again, it is the partnership who will bear the risk of loss, because there is, again, an implied transfer of ownership to the partnership here. Bakit? Kasi, kinontribute mo sa partnership and the partnership will sell it to another person. And remember here, class, the partnership cannot sell what it does not own. So, obviously, there is an implied transfer of ownership here. That's why the partnership will bear the risk of loss, kasi impliedly, nilipat na sa kanila yung ownership ng things contributed to be sold. What else? Things brought and appraised in the inventory. Partnership will bear the risk of loss. Again, class, nung kinontribute itong object na to with an appraisal, ang parang kinontribute dito is the price of the thing. That's why the partnership will bear the risk of loss. And implied sale again to the partnership. What else? The next obligation, in addition to the 5 already mentioned, is the duty not to engage in any business. Applies only to your industrial partner. This should be taken in relation to Article 1808, which we will discuss later on. Anong sabi? Industrial partner cannot engage in business for himself unless there is an express, remember the term, express permission from the partnership to do so. So, remember, class, pagka ang partner na ito ay nag-engage sa business na iba, or basta other business which is not the partnership business, remember, the act is prejudicial to the interest of the other partners. There's actually here a conflict of interest. Kasi nga, alam nyo naman, sa isang partnership, pagka-industrial ka, ang may-ari ng services mo ay ang partnership. So here, remember that you cannot give your service to another business kasi nga meron ng may-ari ng serbisyo mo. It is the partnership. So the effect of violation of this article is, number 1, the capitalist partners, even industrial pala, can exclude the partner from the partnership. What else? Papaalisin ka or hindi ka isasama. And number 2, partnership can avail themselves of the benefits from the illegal business. And partnership will have a right to damages in either case. So remember, exclude plus damages or avail benefits plus damages. So yun ang kailangan nating tandaan sa 1789. The owner of the industry of an industrial partner is the partnership, and he cannot, remember, engage in another business for himself because there is here a conflict of interest with the partnership. The next duty is the duty of a partner to credit payment to the partnership. So this provision will apply only to a managing partner who collects credit from a debtor. So here in 1792, remember, there is only one debtor. That one debtor is indebted to the partnership and also to the managing partner. In short, meron siyang dalawang utang. Now, the managing partner successfully collects a sum from the debtor. Now, let us say, class, yung sum collected from the debtor by the managing partner is a sum for his own account, personal account. So, ang kinolekta niya is yung para sa sariling account niya or yung utang ng debtor to the managing partner. Now, under the law in 1792, the managing partner has an obligation to share yung sum collected with the partnership. So, hindi niya pwedeng solohin to. But the sum collected will be applied to the 2 credits pro rata. So, it will be applied to the debt of the debtor to the partnership and also to the debt of the debtor to the managing partner. So, yun ang kailangan nating tandaan. Kailangan niyang i-share. Bakit ganon? Kinolekta na nga niya for his own personal account. Bakit kailangan pang i-share sa partnership? So, remember in 1792, ang pinoprotektahan niyan is the interest of the partnership. Remember, in a partnership, the interest of the partnership comes first. So, mauuna yan. Kaysa sa personal na interest ng mga managing partners. Bawal daw unahin ng managing partner ang sarili niya. So, if the managing partner collects a demandable sum and it is collected for his own account or yung resibong inisyo niya is for his personal account, remember, hindi niya makukuhang buo yan. But he has to share a portion of it to the partnership. Yan. Kasi nga, the partnership always comes first. Now, what if the managing partner collects a demandable sum for the account of the partnership? Remember, class, that if it is for the account of the partnership, the question is, pwede bang makishare si managing partner dyan? Hindi, class. Pagka ang kinolect ng managing partner is for the account of the partnership, it will be applied only to the partnership credit. So, yung buong amount, mapupunta lamang sa partnership. Bakit ganun na naman? Again, class, the interest of the partnership is paramount. Mas mauuna ang interest ng partnership. So, the next duty, class, is the duty of the partner to share credit received. In 1793 as opposed to 1792, remember, there is only one debtor and one debt. In 1792, as I mentioned a while ago, there is one debtor and 2 debts, one to the partnership, one to the managing partner. 1793, only one debt. So, here in 1793, the partnership has successfully collected only a portion of the debt. And yung portion na yon, ibigay sa isa sa mga partners. Now, what will happen? Ngayon, itong partner na nakatanggap ng share niya, after receiving the share of the said partner, the debtor becomes insolvent. Now, syempre, kung maniningil yung partnership, wala na silang masisingil from that debtor because he has become unable to pay his obligation. Now, itong debtor, itong partner na nakatanggap ng kanyang share in whole or in part, is supposed to return yung kanyang share na natanggap to the partnership para paghahatian nila yung share that he has received. So, take for example, debtor may utang siya na 9,000 sa isang partnership, tapos merong 3 partners. The partnership successfully collects, let us say, 3,000 pesos from this debtor, and yung 3,000 na yan, it is received by A, one of the 3 partners. Now, later on, itong si X becomes, itong debtor becomes insolvent. So, there is no way for the partnership to collect yung balance from the obligation. Now, what happens here is that A will have to give again to the partnership what he has received from the insolvent debtor, yung kanyang share doon sa credit, and then the credit received and returned to the partnership will be shared by all of the partners. So, doon sa 3,000 na binayad nung insolvent debtor before he became insolvent should be divided amongst the 3 partners. So, tiggo 1,000 yung mga partners. So, remember, ito ang application ng 1793. What else? Duty to pay for damages. So, here, the damages is caused by the fault of a partner. Obviously, kung kasalanan mo, you have to pay for damages. So, remember here, class, that even if that partner who caused damages to the partnership, he earns profits and benefits, hindi pwedeng i-compensate ito. So, please take note again of the concept of compensation, which I am sure you have already studied in obligations. So, remember, compensation happens when both parties are in their own rights creditors and debtors of one another. So in compensation, may utang ako sa'yo, may utang ka sa akin, so alangan namang magbayaran pa tayo, quits na lamang. Quits yung utang, so wala nang bayarang mangyayari. Anyway, we are indebted to one another in our own right. So the obligation we have to one another is extinguished by operation of law. Now here, remember, in 1794, the partner who causes damages to the partnership is not allowed to compensate with yung damages caused with the profits and benefits earned by his industry. So let us say partner causes damage to the partnership in the amount of 100,000. Later on, same partner who caused damages to the partnership earns earns 200,000 for the partnership. Remember, hindi pwedeng quits na lang, wala na lang bayaran. Kumbaga, may balance na lang yung partner na 100,000 pesos. Hindi pwede yon. Remember, they cannot be compensated against one another. Why? So, remember here the reason for non-compensation or not offsetting yung damages with benefits is they are both duties of the partner. So, here class, remember, a partner has duty to secure benefits for the partnership and he also has a duty not to be at fault. So, parehong duty ng partner yaang dalawang yan. So, secure profit is the duty of the partner. Partner also has a duty not to be at fault or not to be negligent. So, in simpler terms, duty not to cause damages. Now, kung parehong duty yan, the partner is the debtor in both instances. That's why compensation cannot take place. So, hindi pwedeng ma-offset, hindi pwedeng quits na lamang sila. Because here, in both instances, again, the partner is the debtor. Hindi sila nagpalit ng roles. That's why compensation is not allowed. However, the courts may mitigate or lessen yung damages which are to be paid by the partner. When, if the partner through his efforts acquires profit for the partnership. The efforts here must be extraordinary efforts, sabi ng law. When we go back to this slide, you can see class, unusual profits were realized due to extraordinary efforts. So the courts may mitigate or lessen, babawasan lamang yung liability. But totally hindi pwedeng totally alisin yung liability ng partner. For after all, remember, he caused damages to the partner and dapat maging liable siya doon. So anyway, let's go ahead with another duty. Duty of here. Remember here class, in 1796, ang pag-uusapan naman natin is duty ng partnership to partners. Ito yung medyo naligaw na provision. Although, as you have already seen a while ago, meron ding mga ibang naligaw pa. Anyway, basta ma-discuss mo lahat, walang problema yan. So, duty to refund, duty to answer for obligations, give effect to contracts, and duty to answer for risks. So, the duty to refund is pagka may inabunuhan ang partner, the partnership must refund or reimburse yung partner who advanced any amount on behalf of the partnership. So remember, plus legal interest yan. What else? Duty to answer for obligations or give effect to contracts. Pagka pumasok sa contract ang isang partner, and if he is sufficiently authorized by the partnership, remember class that the partnership has a duty to the partner to recognize yung transaction or obligation na pinasukan nung partner na yan. So the partnership has an obligation to give effect to the contract entered into by the partner. So the last one is the duty of the partnership to answer for risks as a consequence of management of the partnership. So these are personal losses to the partner who manages the partnership because of yun ngang duty niya na mag-manage ng partnership. So, let us say class, there is a loss of the property of the manager, and it happened because of his duty to manage the partnership. Remember class that the partnership will be answerable for the risks taken by the managers para lang sa management ng partnership. What else? Also, remember profits and losses. So, again, in case of a partnership, a partner not only shares in the profit but also shares in the losses. So, paano nga ba i-distribute ang profits? In 1797, remember, profits are distributed according to agreement. So, kung ano ang napag-usapan na profit sharing, yon ang susundin. Ma'am/sir, paano po kung walang napag-usapan? Siyempre, kung walang napag-usapan, remember class, the share of each capitalist partner shall be in proportion to his capital contribution. So, tingnan natin kung ano yung kanyang capital contribution. Kung 10% ng capital kinontribute niya, ang profits na kanyang makukuha ay 10% din ng profit. So, yun ang tandaan natin. And also, what about an industrial partner? So, remember, an industrial partner will receive just and equitable share under the circumstances. What you have to remember is that the industrial partner is given first yung kanyang just and equitable share under the circumstances before yung share ng mga capitalist partner ay ibibigay. So let us say there is a profit of 100,000. Tapos yung isang partner yung isang partner ay industrial partner. Let us say for the services of the industrial partner, ang just and equitable share niya is, let us say, 20,000. So, yun muna ay ibibigay sa kanya. So, yun ang kanyang share. First, yun muna ang isettle. Pagka-settle noong share ng just and equitable share ng industrial partner, yung 80,000 will be distributed to the capitalist partners in proportion to the capital contribution. So, yun ang kailangan nating tandaan in 1797. We will discuss more of that when we have our class on Saturday with examples. Doon na lang siguro para mas madali. So, anyway, also, losses naman is distributed in accordance with the rules in 1797 also. So, pagka losses, remember that, tignan muna natin, meron ba silang loss sharing agreement? So, tignan natin, kung may loss sharing agreement, obviously, you have to follow the loss sharing agreement. Ang sinabi lang naman ng law, the loss sharing agreement must not be unfair, must not be iniquitous, meaning, yung isa 100%, let us say yung isa 99% loss, na isang partner 99% loss, tapos yung isa 1% lang ang share niya. Hindi pwedeng yung mga ganong klaseng agreement or sharing when it comes to losses. So, anyway, paano kung wala po tayong loss sharing agreement? Tingnan natin kung meron tayong profit sharing agreement. And remember, class, na yung ating sharing sa loss will be based on the profit sharing agreement. And again, here, industrial partner shall not be liable for losses. Remember that very well. We will discuss more when we go to the other provisions. Also, number 3, what if, ma'am/sir, ala pong loss sharing agreement, ala mo ring profit sharing agreement, anong basis ng share sa losses? Remember class, yung capital contribution will be the basis of the loss sharing. So, depende kung ilang percent ang kinontribute nila sa capital, ganun din yung percentage na isi-share nila sa loss. Again, industrial partner will not be liable for losses. Examples when we come to class. What else, class? Third persons can designate the shares of the partners in profits and losses as long as yung designation is made with the common consent of the partners. Pero hindi pwedeng isang partner lang, hindi pwedeng isa sa mga partner ang mag-designate ng profits and losses. So anyway, also, obviously, if a third person designates yung sharing in the profits and losses, it may be questioned by the partners, or ang ginamit ng term ng law is impugned. So, if it is manifestly inequitable, very obvious that the profits and loss sharing is unfair. So if it is unfair, remember class that the partners may question it, except when, remember the exceptions in 1798, even if it is manifestly inequitable, the partners can no longer impugn or question yung designation by a third person if, number one, aggrieved party or yung party who suffers unfairness or suffers inequality, yung siya yung nadehado, began to execute the decision. Ibig sabihin, tinanggap na niya yung kanyang maliit na share, yung kanyang iniquitous share. He already received it or distribute niya in accordance with the unfair agreement. Remember, class, that he can no longer question. Kasi ginawa mo na sinunod mo na. Paano mo pang i-question? What else? Number 2, if he has not impugned the same within 3 months from the time he is made aware of the making of the designation. Sinabi, ito ang share mo sa profits, ito ang share mo sa losses. Tapos, feeling niya unfair. Kasi sa profits, ang share niya is 10% lang. Sa losses, ang share niya is 90%. So, tataka ka, bakit ganon? Pero hindi niya question kaagad within a period of 3 months. Remember, class, that he can no longer impugn or question the designation made by a third person. What else? In addition to that, profits and losses, you can exclude a partner from profits and losses, sabi sa 1799. But remember, class, this is only an exception. The general rule being, there can be no exclusion of one or more partners from share in the profits and losses. Bakit? Common benefit and interest of all partners ang isang partnership. So, kailangan everybody will participate in profits, everybody will participate in the losses para lahat mag-benefit, lahat mayroong interest. So, general rule, the law does not allow stipulation excluding one or more partners. But else, also remember, even if the stipulation is void, it will simply be disregarded and the partnership will continue as a valid partnership. Anyway, exception, katulad nga ng sinabi ko, industrial partner may be excluded from losses. Yan. So, in case of losses, remember, pwede natin i-exempt ang industrial partner. Bakit? Kasi law na mismo ang nagsabi, industrial partners are excluded from losses according to 1797. So, hindi siya kasama sa loss, obviously, even by stipulation, although that is redundant already kasi nga law na ang nagsabi. And remember, class, that this exception is without prejudice to the rights of third persons. Itong tandaan nyo sa 1797 in relation to 1799 and also 1817. An industrial partner is exempted from losses, but he is not exempted from liability. So, kung ang third person or creditor will demand payment from the partnership, the industrial partner must pay. Kasi nga, liable pa rin siya. So, he is not exempted from liability. However, because an industrial partner is exempted from losses, even if your industrial partner pays the creditor/third person, he can ask for reimbursement from the capitalist partners. So, kahit na nagbayad siya, makakakuha siya ng reimbursement from the capitalist partners. So, that is the reason why, even if he is made liable, he is excluded from losses because of his right to ask for reimbursement from the capitalist partners. So, yun ang 1799. So, management is discussed under 1800 up to 1803 of the Civil Code. Remember here, class, that pagdating sa management of a partnership, when we talk about 1800 up to 1802, we are talking about partners who are appointed as managers. So, if a third person is appointed as a manager of a partnership, these rules will not apply kasi nga third person yun. Not a member of the partnership. So, remember, in 1800 up to 1803, partner has a right and a duty to manage the partnership. So this is both a right and a duty at the same time. Obviously, it is a right because partner has an equal voice in the conduct of the partnership business. So, kailangan, syempre, makialam sila and gusto nilang makialam sa management ng partnership nila. That's why it is a right to manage the partnership. What else? It is also a duty. Alangan namang walang mag-manage ng partnership. So, remember, both a right and a duty. Now, there are two cases of appointment. Meaning ito yung dalawang paraan para paano i-appoint ang isang managing partner. So, remember here class, in 1800, sabi niya, managing partner can be appointed in the articles of partnership or contract of partnership. So, yung appointment as manager in the articles of partnership is a part of a stipulation in the contract of partnership. So, yung partners, they agree that one of them will become a managing partner and nakalagay yan sa articles of partnership or sa contract of partnership. So remember, the managing partner here is appointed by common agreement and it is a stipulation in the articles of partnership. What else? Also, appointment as a manager after constitution of the partnership or it may be made orally. So obviously, here in number 2, meron ng partnership as a ongoing concern. Na-establish na yung partnership, then afterwards, the partners will agree na one of them will become a manager of the partnership. So, what you have to remember in number 1, if you are appointed as manager in the articles of partnership, being a part of the partnership contract, yung appointment mo, it is not easily revocable. So, hindi pwedeng basta-basta na lang nilang bawiin yung power na binigay nila sa'yo as managing partner, especially since it is a stipulation in the contract of partnership. So, dahil ito ay stipulation in the contract of partnership, to remove a managing partner who is appointed in this manner, remember that there must be a just and lawful cause and there must be the vote of the controlling financial interest. So, remember, para i-revoke ito, just and lawful cause and vote of the partners representing the controlling financial interest. So, that is 51% of the financial interest, at least. What else also? In case of appointment as manager after constitution of the partnership or even verbally, it is a mere delegation of power. It is revocable at any time. Kasi nga, hindi naman ito part ng partnership contract. That's why you can be removed anytime if you are appointed in this manner. What else do you have to remember? Powers of a managing partner. All necessary and incidental powers to carry out the objectives of the partnership. So, lahat ng necessary, lahat ng incidental. All acts of administration actually is included in the powers of a managing partner, except when number 1, the powers are specifically restricted or expressly withheld. So hanggang dito lang ang pwede mong gawin or bawal mong gawin yan. So yun ang exceptions. So remember, hindi nila pwedeng gawin yan. It is outside the scope of their powers. What else? Managing partners cannot also exercise powers which are not necessary or not incidental to the objectives of the partnership. Outside na ito ng powers given to your managing partners. What about in 1801? In 1801 and 1802, remember, 2 or more managers are appointed. So the appointment of the managers may be in the articles of partnership or subsequently after the Constitution or even verbally. But in 1801 and 1802, what you have to remember is that there is a plurality of managers. 2 or more ang inappoint. Siyempre, kung 2 or more managers, here in 1801, yung duties nila is unspecified, meaning kahit na ano pwede nilang gawin, and unanimity is not required, meaning they do not have to have or get the consent of the other partners in order to act. So, pwede nilang gawin kahit na unspecified kasi yung duties nila, and pwede silang dumiskarteng mag-isa. Yun ang 1801. So, yan ang provision na yan. So, each managing partner may separately perform acts of administration kasi nga unspecified ang duty and unanimity is not required. These are the rules in case of opposition. So, obviously, pagka 2 or more kayo, there are times na the managing partners will not see eye to eye. So, there will be oppositions. What you have to remember in case of oppositions is only managing partners have the right to oppose. Yun ang kailangan yung tandaan. Number 1, rule in case of oppositions, decision of the managing majority will prevail. Yan. So, let us say, class, there are 3 managing partners. Tapos, A, B, and C are the managing partners in a partnership, which includes also E and F in the partnership. Yung 3, managing partners. Yung 2, they are not managing partners. So, let us say, class, si A, meron siyang ginawang act, and the act of A is opposed by B. So, how will they resolve the conflict since there is opposition here? So, if there is opposition here, remember, class, that it will be resolved on majority or per head voting. So, let us say A, meron siyang action, B, oppose. Let us say si C, kumampi kay B. So, remember, class, yung decision ni B will prevail, or the opposition of B will prevail. Per head ang voting. So, 3 sila, obviously, very easy to break the tie. How about if in case there are 4 managing partners? A, B, C, and D are managing partners. Tapos merong action si A, opposed by B. And syempre, paano natin i-resolve yan? By per head voting. Let us say, class, C, kumampi siya kay B, si D, kumampi siya kay A. So, 2:2. There is a tie. Yan. So, anong gagawin natin ngayon if there is a tie? The matter shall have to be decided by the vote of the partners owning the controlling financial interest. Meaning, isama na natin yung mga ibang partners. So, hindi lang ito ang boboto, pati ito na isang ordinary partner or non-managing partner, boboto na siya. And remember, class, that the matter will be decided by the financial interest of the partners. So, titignan na natin kung magkano ang mga contributions nila, kung ilang percent, tapos i-add natin yan. Tapos, doon natin ma-determine kung ano ang decision ng partners. Anyway, more on that when we have our class on Saturday. We will have a concrete example of that so that mahirap kasing mag-imagine. And kailangan ko magsulat sa whiteboard, mahirap. Kala na. So, 1802 naman, there are, oh, by the way, class, in 1801, remember that if there is a specification of the duties, ibig sabihin, may toka yung mga managing partner. Ikaw dito, ikaw sa accounting, ikaw sa hiring ng employees, etc. So, if a managing partner hires this employee, kasi yan ang kanyang designation ng kanyang duty, hindi pwedeng mag-oppose yung isa kasi merong specification ng duties here. So, kung sino ang nakatoka dun sa duty na yon, siya lang ang may right to decide as long as he is in good faith. Hindi pwedeng i-oppose yan. So, what else in 1802? Remember here, class, again, 2 or more managers and unanimity is required. Meaning, the managers cannot act without the consent of the other managing partners. So, wala silang magagawa kung hindi nila nakuha yung boto ng lahat. That is the general rule in 1802. So, if unanimity is required, even the absence or incapacity of the other managing partners is not an excuse. You have to get the consent of all before you can enact anything. Bago ka makakilos to do any action, you have to get the consent of all of the managing partners because in 1802, unanimity is required, meaning the vote of all is required. Now, that is the general rule. Diyang absent lad, diyang incapacitated lad, even if they are abroad, remember, you have to get their consent, you have to get the vote, except when, number one, actually only one, when there is imminent danger of grave or irreparable injury to the partnership. So, if merong loss which is imminent to the partnership or may injury, kung hindi natin ginawa ito, there may be injury suffered by the partnership, yung managing partner may act alone even if hindi pa niya nakuha yung consent ng ibang mga partners. Kasi nga, if not acted upon, yung incident may cause grave or irreparable injury to the partnership. So, let us say, class, ang isang partnership, meron silang building, yan ang building. So, yung building nila is about to be foreclosed by the bank. So, malapit na siyang ma-foreclose ng bangko, malapit na siyang marimata. So, itong managing partner na to, even if, and he is acting under 18, his power is covered by 1802. So, balak na niyang tubusin yung property na maririmata na ng bangko. Remember here, class, that even if he does not get the consent of the other managing partners, let us say they are abroad, ganun na lang. Because irreparable injury to the partnership will be caused kung hindi niya natubos ito, pwede niyang tubusin. Kasi nga, he can act alone because if inaction will cause grave or irreparable injury to the partnership, the law allows him to act alone. Kasi nga, pagka nawala yung property ng partnership, grave injury, irreparable injury. That's why he is allowed to act alone even if without the consent of the other partners. What else? Also, 1803 here. In 1803, kung 1802 or more managers are, 1801 and 1802 or more managers are appointed. In 1803, walang inappoint na manager ang partnership. So, not a partner is appointed as manager, not a third person is appointed as manager. What is the rule now? All partners are considered as managers because nobody is appointed as a manager or there is no agreement as to the management. All partners are considered as managers. So, remember, what any one of them may do alone shall bind the partnership, subject to the provisions of 1801. So, dahil lahat sila ay managers, if may act yung isa, let us say 5 sila, o managers silang lahat. Tapos, merong act yung isa, so anybody, any of the 4 can oppose because they are considered as managers, all of them. So, yun ang kailangan nating tandaan. And also, in case of oppositions, the rules in 1801 will apply. So, kung ito, mayroong siyang action, ito nag-oppose per head voting. So, kung nagkaroon ng tie, remember, controlling financial interest vote of all of the partners will be considered. Anyway, more examples later on. However, class, in number 2, in case there is an important alteration in an immovable property of the partnership, again, unanimous consent or the consent of all of the partners are required. Yan. What else? Right to appoint an associate. So, right and duty, actually, in 1804. So, an associate, also known as a sub-partner. So, isa kang partner, pwede kang mag-appoint or mag-associate ng another person, third person in your share. So, yung share mo will be received by this associate. So, an associate is not a partner. So, he is not liable for the debts of the partnership. So, yung associate is only concerned with the share of the partner who appointed him. So, also, obviously, your associate must be admitted by the partnership. So, it is the duty of the partnership to admit the associate. So, to appoint an associate, remember, you do not need the consent of the other partners. Yan. What else? Partnership books, 1805. Also a right and also a duty. So, each partner has a right to inspect and copy the partnership books. The partnership book should be kept at the principal place of business and can be inspected during reasonable hours. Reasonable hours, business days throughout the year, and not merely some arbitrary or capricious period selected by the managers. Hindi pwedeng sabihin ng mga managers, o pwede mo lang inspect yan ng August to September every year. Hindi pwedeng ganun. So, it must be available for inspection on business days throughout the year. So, basta ang limitation lang is it should be reasonable hours. Yan. What is reasonable hours? Probably business hours. 8 to 5. Yan. What else? Also, kung right yan, the managing partner or the active partner has a duty to keep partnership books. Yan. Subject to inspection of other partners. So, Article 1806 talks about the duty to give information. So, each partner is required to give true and full information on demand. There must be no concealment. Again, a partnership is a relationship of trust and confidence. So, bawal magtago ng information. Persons who can demand information under 1806 is any partner, the legal representative of a deceased partner, and the legal representative of any person under legal disability. What else? So, fiduciary duties of a partner. Again, relationship of mutual trust and confidence. So, fiduciary relationship ang tawag dyan. So, remember, duty to act for the common benefit. So, dapat lahat ng ginagawa mo is for the benefit of all of the partners and also for the benefit of the partnership. Yan. So, what else? Duty to account for secret and similar profit. So, remember, any secret profit or any secret commission that is made by the partner should be also accounted for in favor of the partnership as well as the other partners. So, bawal yung may mga kickback or merong mga konting kinita on the side. Remember, kailangan mo pa rin i-declare yan sa partnership. What else? Duty to account for earnings accruing after termination of the partnership. So, remember, if meron pang na-collect na profit or earnings after the partnership has already been dissolved, kailangan pa rin itong i-share ng collecting partner to the other partners. So, even if yung earnings na to, it is realized after the dissolution of the partnership. What else? Duty to make full disclosure of information affecting the partnership. So, any knowledge na nakuha ng partner during his time as a partner must be fully disclosed to the partnership. Yan. So, kailangan sabihin niya sa mga partners kung ano yung mga information as long as the information is gathered at the time that he is a partner in the partnership. Yan. So, remember, 1808 in relation to 1789. Capitalist partner, remember in 1789, sabi, industrial partner cannot engage in any business which is not the partnership business. Bakit? Kasi there is a conflict of interest. As you all know, as I've already mentioned already, it is the partnership who is the owner of the industry of an industrial partner. However, in case of a capitalist partner, they have a duty not to engage in unfair competition. So, pwede siyang mag-engage in another business. But remember, he cannot engage in a business which is of the same kind or nature as the business of the partnership. So, kung ang business ng partnership ay selling cellphones, buy and sell ng cellphone, itong capitalist partner can engage in any business except the buying and selling of cellphones. Bakit? Kasi remember, kung mag-engage siya sa same business, there is unfair competition. Dahil magagamit niya yung knowledge na nakuha niya sa partnership business para gamitin dun sa kanyang personal na business. So, there can be business secrets, etc. na pwede niyang magamit dun sa kanyang personal business, and this would be unfair on the part of the partnership. Yan. What else? Violation. What are the effects if you violate 1808? The capitalist partner who violates this provision will bring to the partnership all the profits obtained illegally. What else? Partner will personally bear all the losses. What else? The partner can also be removed from the partnership on the ground of loss of trust and confidence. Remember again, a partnership is a fiduciary relationship. So kung nawala na yung trust and confidence, pwedeng alisin itong capitalist partner na to. What else? Formal accounting, 1809. So the right to demand a formal account is covered by this rule. So the general rule is formal accounting is demandable only after dissolution. So anyway, pwede namang makita yung mga books ng partnership. It is available for inspection at reasonable hours during business days. So, hindi naman talaga kailangan ng formal accounting except pagka nagdi-dissolve na yung partnership. However, there are exceptions to this rule. In case of exceptions, number 1, if a partner is wrongfully excluded from the partnership business or possession of specific partnership property by the partners. So, here, ayaw isama itong partner na to, wrongfully excluded, ino-OP siya, hindi siya pinapasama sa mga meetings, etc. Ayaw siyang isama sa management, etc. So, hindi siya makaparticipate sa business. He can ask for a formal account para nga naman malaman kung ano talaga ang nangyayari sa partnership. What else? The right exists under the terms of any agreement. So, if it is agreed upon that formal accounting is available without necessarily resorting to dissolution of the partnership, pwede, because there is an agreement to that effect. What else? Also, formal accounting is available in case of Article 1807 when a partner has derived profits from any transaction. So, remember in 1807, I've already discussed that if mayroong unauthorized profits ang partnership, ay unauthorized profits na napunta sa isang partner, remember class that the partner will hold yung unauthorized profits na yon as a trustee for the partnership. So ngayon, dahil nga nasa kanya yung halimbawa, property, land, tapos sa partnership talaga siya, pero naipangalan sa partner. Remember class here that the profit is illegally obtained or the property is illegally obtained. Remember class that if that is the case, the partner does not become the owner but becomes a trustee of the partnership with respect to that property. And pagka nagkaroon ng mga properties na ganito, pwedeng mag-request ng formal accounting yung mga ibang partners para malaman syempre kung ano yung extent ng ownership talaga ng partnership, ay ng extent ng assets ng partnership, kasi they have to factor in also yung mga properties which are held by other partners in trust for the partnership. What else? Also, other circumstances render it just and reasonable. So, obviously, other circumstances pwedeng manghingi ng, as long as it is just and reasonable, a partner can request for formal accounting even if the partnership is not yet dissolved. So, that's it for Chapter 2, Section 1. We will try to finish this discussion in one meeting. The results of your quiz number 1 have already been released to your given email addresses. If you do not get your results, please contact Niklas. I wonder kung sino ang nakaabot hanggang sa dulong portion ng recording na to, because obviously hindi nyo napapanood lahat. Anyway, again, this video will be restricted on Wednesday next week. Remember to take notes already, etc., etc. So, class, that is all for today. Have a good day.